Good afternoon, everybody. You're very welcome to our meeting this afternoon. We look forward to a really lively session. Anne O'Carroll, I have known for a number of years. She's been a trainer in legal matters for the Citizens Information Board, and she wrote the training on consumer rights for us. And you're very welcome to join us today. I know this is a topic that is close to your heart and close to many other people's as well, although many people are reluctant to engage in the topic. And what developed your interest in this particular topic?
Well, I suppose sharing the mortality with the rest of the human race. I was writing about legal topics, and the legal topics that attract me are ones that attract everybody, and family and wills particularly attracted me because everybody has a family, and everybody originates in a family, and everybody dies. So I just figure that they have a lot of applicability. And also, I suppose my forte is taking complex legal things and making it really, really accessible to the layperson. And while the layperson mightn't be all that interested in learning about house conveyancing or anything, when it's close to home, when it's about family and money and death, basically,
Yes.
a lethal combination, then people's interest is piqued. So I just thought it's something as well that I came up again and again about terrible, really tragic situations, because normally they only arise after someone has died, that were totally avoidable. And I thought, this is so avoidable if only people were better informed. So that's really what drew me to it, because information is my passion, really.
Yes, I remember one of the training courses that you gave on this topic. You mentioned how things can go wrong, and that people may think they've done everything right, and it's only until after the event that they discover that something disastrous has happened. I remember you telling the story of one farmer's wife listening to, I think it was Pat Kenny's program, and hearing, one thing you must make sure when you get your will, that it must be signed. So she reached into the tin box, got the will out and signed it, and just in case. But she was a beneficiary, and therefore, because it was signed, she couldn't benefit.
Yeah, she unwittingly made herself into a witness. Exactly. A little knowledge is a dangerous thing. So you're not going to get everything that you need today to go off and make your own will, but you definitely will be able to be clearer about why you need to instruct a solicitor and what kind of instructions to give them.
So you would not advise people to Google making a will and then to write a sheet of paper, leaving everything to the dogs and cats home?
No, not really, because even a will that looks that simple, like I leave everything to the dogs and cats home, it's amazing what could go wrong. So definitely it's a much better idea to get professional advice. But what I try to do is inform people beforehand, so they're going in informed about how they need to instruct their solicitor, because the solicitor can only do what you tell him or her to do. So I think when people have a clear idea of what they can do with a will and all the pluses, and can streamline that will to their own personal circumstances, it becomes a much more valuable document.
Good. Well, I'm going to hand over to you, Anne.
Okay, so you're all very welcome. I just will give you a little advance warning that normally this would be a 3 or 4 hour training course, or if it was a public information presentation, it would be probably about 2 hours. So we're pretty constrained today with time. So I made the decision to leave a lot of my slides in, but I will be skimming over them and really just picking out the key elements for you. So if you feel a little bit frustrated, please don't try and read all the information that's on the PowerPoint slides. It's really just, you can skim over it. I'll give you the key points and we'll move on. But just that you know that there's more to it as we go along. So I entitled this presentation, "Making a Will Won't Kill You." And I did that on purpose because I'd like to address the very real reluctance that everybody has about making a will, because I'm going to be talking about situations here which are not the usual things you talk about on a Monday lunchtime. Your own mortality, the world continuing on after you're gone, horrible sort of scenarios, like worst case scenarios, like children being orphaned or vulnerable people being left unsupported and stuff like that. So it's not really the kind of thing we like to think about. We like to shy away from it. And I just try to inject a little bit of levity with "Making a Will Won't Kill You" to say, really, it's worth grasping the nettle. You'll learn something that'll be useful to you, and it's worth getting over that initial discomfort, because you can really do something to protect yourself and your loved ones through making a will. So idea of this talk, and also I'm going to be bringing out a downloadable kind of product that is for people who want to make a will, that will give them, it's kind of a step-by-step guide They will help people to prepare for making a will, because there's a lot of pre-preparation you can do. They will inform you on what your various options are, so you can really think through the choices you want to make. That will definitely encourage you to make a will, mainly by giving you horror stories about what happened when people didn't make a will, or almost as bad, made a homemade will, probably worse, made a homemade will. And then what I want to do is encourage people to act, not just say, oh, that was very interesting, but to actually galvanize into action. So like I said, I'll be launching this downloadable product on the line, but you're getting it today, courtesy of the Rotary Club in Kilkenny. You get a sneak preview of everything. So we'll be looking at things like reasons for making a will, and very importantly, what will happen if you don't. Also, the step-by-step guide on how to make a will, or what the steps are that you need to take in making a will, and what you can use your will to do, because it's a really, really flexible kind of legal structure that you can use to that you can tailor make to your own requirements within the law. Equally important is to know what you can't do with a will, and that's actually quite illuminating for most people. And I look at some of the practical elements of what happens after you die. For example, a lot of people don't realize that all of your assets will be frozen. Your bank accounts will be frozen. No one can touch a penny in that bank account until probate is through. So that can lead to an awful lot of hardship. So I'll be looking at practical things you can do to reduce that. And then obviously inheritance tax is a big issue for a lot of people. So we'll be looking at ways that you can reduce inheritance tax legally. And a kind of a launching off pad at the end of where I go from here will enable you to ask a few questions as you go along. I would just say there's no point asking me any questions. If you could address any of your questions in the chat to Ian, he can raise them with me. And also you'll have the option to maybe have a wee chat at the end. So this is what we'll be looking at today, the key points of all of those. So how you can talk to us, like I said, is the chat function. Also, I'll be doing one or two just little quick polls on screen, which are easy to access. And the final Q&A, you can press your reaction button or just raise your hand and Ian can unmute you. The first thing I'm going to look at is the reason. Why would you make a will? And most people think, money, 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 money. What about my property? I think of it in terms of the 4 Ps. Protection of vulnerable people in your life, particularly children, particularly underage children. And a lot of people who are young families with young children, you're obviously run off your feet raising said children, and you're not thinking about potential orphandom or worst case scenarios. It's not really to the forefront of your mind, but it is something people need to consider. People who have underage children do need to consider making a will, because their children will need to be protected in more ways than just monetarily. And this provision, which is what most people think of, providing for your dependents and your loved ones, seeing who gets the dosh. Preserving your assets. If you do a badly made will, you can end up with huge tax bills for the people who are getting the money, and there are ways that you can avoid that perfectly legally. So how to preserve your assets and how to make sure that your assets aren't sort of divided up into such small pieces that they're not maybe valuable anymore. Then peace of mind. This is very much underestimated, but I can tell you personally, having made my own will 2 or 3 times, sometimes in extremis, and having seen family members who were quite ill or who were in a precarious sort of family situation and very concerned and worried about certain aspects of the family dynamic in their lives, having made a will gave them enormous, enormous peace of mind that really can't be underestimated. Those for me would be the 4 Ps: protection, provision, preservation, and peace of mind. And my motto is always prepare for the worst and hope for the best, which I think you can use this to do. So the reasons for making a will then are many and varied. Young children, I've mentioned that, extremely important if they're under 18 because they're minors. So if you die without having made a will and you have 3 children under 18 and they inherit everything automatically, they'll be made wards of court because they're too young to inherit the money. And the money will have to be lodged in court. And every time you want to buy a pair of shoelaces, you'll probably have to go to the High Court. I'm exaggerating slightly, but it's a very unwieldy process that you can avoid by making a will. You think about vulnerable dependents in your lives, maybe people with special needs, or someone is elderly or in initial stages of dementia, or just frail. Obviously, you want to make sure that your house, your property, your savings are taken care of. Something that people don't consider is that if they're self-employed, and I would count a farmer in there, that you really need to think about making a will to ensure that the main asset continues to generate money for their family. It's particularly important if it is the self-employed person who dies, because not only is everyone distraught, bereaved, in a state of shock, but the main wage earner is gone, and whole businesses can just founder in that circumstance, particularly farms. So for the reasons for making a will, you might have a kind of a complex family setup. So we'll have a look at this family here. So the woman there and the man may be living together, or they may be married. The older girl that the woman's holding the hand of might be her daughter by her first marriage, and she's divorced. The girl out there on her own might be the father's daughter by his ex-girlfriend, and they might never have married, but they're separated. And then the child in the middle might be both of their children.
Yeah.
So you're talking a situation there where you have step parents and half brothers and sisters, half siblings, and so on. So it's quite a complex family dynamic in a blended family, and that's another reason that it might be good to take a will, to take cognizance of that. Now, I don't know how many bomb disposal experts there are in the audience. I suspect very few, but if you do have a risky job or a lifestyle, and I come from a fishing community in Castletownbere in West Cork here, I know probably 40 people who have drowned in the 25 years that I've been here. So that is a very risky job, and that is definitely, if you're in the armed services or whatever, reason for making a will. Old age, alas, is going to come to us all, and a bit of wisdom. So health issues as well can crop up very suddenly, or can be what lies ahead of us. And addiction issues, this is an area people don't really think about, but if you have someone in your family, or if you yourself have addiction issues or alcoholism issues, it may be necessary to make a will that would take that into account and would structure the how the beneficiaries receive the money, so that it doesn't actually harm them to get a big inheritance. Violence in the home as well, especially if you're in a situation where you're separated, and there might be violence or family members who are violent, and you need to take that into account. And family disputes as well, because as they say, where the will is a relative, and if there's this cousin or the brother or the uncle or whatever who always stirs it up and is always making a fuss, you want to have a good watertight will so that they can't put the cat among the pigeons. So as you can see, there's an awful lot going on there, and you can pick out yourselves which of these aspects and areas would relate to you. And a lot of these would be very, very good reasons to make a will. Just looking, this is the most recent research that's out there, unfortunately, but it's more or less pertinent today. This is the percentage of people who do not have a will in Ireland. I know now it's about 10 years out of date, but it's more or less the same. Over 65 people have a bit of sense, and you only have about 15% of people not having a will, but still I consider that to be high. From 45 to 64, people are copping on a little bit, and nearly half would have made a will. But the really frightening figure there for me is 2/3 of Irish people between the age of 35 and 45 don't have a will. And you might say, well, should they're 35 to 45, why would they bother? But when you think about it, who has young children? Who has children under the age of 18? Usually 35 to 45-year-olds. So my rule of thumb is, as soon as you have a child, as soon as you get a property, you need to start thinking about making a will automatically. So I'm hoping we'll be able to buck this trend anyway in Kilkenny and change the chart. So we might just do a quick poll now, if I can get down to it, just of people here. And this poll is completely anonymous. I'm just going to, relaunch polling. Yes, continue. Okay, so this poll should come up on your screens. You can let me know, Ian, if it's not there. You need to unmute yourself.
Yep,
and I'd like
there.
you just, that's there. Okay, so everybody can just click on the one that is relevant to them. So have you made a will? Yes, no, or I'm not sure. And if you have made a will, was it made in the last 3 years, between 3 and 5 or whatever? So you just tick on that. I can see the results coming in, and it's completely anonymous. And then I will share the results at the end with everybody. So we have 8 of 28 people have voted here. So, I mean, some of you mightn't be able to, want to, or be interested. That's absolutely fine. But any of you who want to, just indicate that there. It's nice to get a ballpoint kind of ballpark figure. So I have news for some people here. Okay, so we were doing pretty well so far. 12 of the 27 have voted, and 92% have made a will. Some with that, but don't rest on your laurels too soon. Okay, so is everybody happy enough? I'll end the polling. Okay, so what we have here is sharing the results that 92% of the half of you who voted have made a will, which is great. Well done. I congratulate you. And 8% haven't. Okay, but the question that those of you who have made a will need to ask yourselves is, what group do you fall into in the second one here? Only 8% have made a will in the last 3 years. And all the rest of you who have made a will made it between 3 and 5 years ago, or a third of you 5 to 10 years ago, and another third of you, so 2/3 of you, between longer than 5 years ago. And the message I have for you is that if your will has been made longer than 3 years ago, you need to pull it out of the drawer and have a look at it. It's something that you need to refresh. I'm not saying that the will go off. It's not a fish, but it's like a suit of clothes. If you get clothes and it fits you beautifully in your 20s, that same suit of clothes, it's still hanging in the wardrobe 20 years later, but it may not fit your requirements. It's exactly the same with a will. If you made the will over 10 years ago, I can bet you that your circumstances have changed in the meantime. You may not need to remake the will, but you absolutely need to take it out about every 3 years and have a good look at it. And I speak from experience here because I had to do this myself. I said, oh, I haven't looked at my will for 8 years. I made it when I was pregnant with my first child, and he's 8 now, so I might as well take it out and take my own medicine. So I really did not expect that I would want to change the will at all. And when I took it out, I was scandalized at how many things had changed in my life and how the will was completely unfit for the purposes, and I had to rewrite it again. So that's just something that I would definitely say to people. It's not like it will go off. It doesn't run out. It's always going to be valid, but it may not suit your requirements anymore. Okay, so what happens if you don't make a will? Looking at this quickly, I need to talk about the terms testacy and intestacy. So you're probably familiar with these. If you die testate, it means that you A, have made a will, B, it is valid, and C, people can find it. Somebody knows where it is. That's very important. If any of those are missing, you're intestate. If you haven't made a will, or you made one but it's invalid, or you made one and it's valid but nobody knows where the hell it is, having searched for years and months, then you're said to have died intestate. So those are the two very different circumstances we'll be looking at here. And the question to ask is, what happens on intestacy? So that's what we're looking at first. What happens if you do not make a will? Once you've seen this, those of you who haven't made a will will be beating a path to the solicitors. On intestacy, where no valid will can be found, the Succession Act of 1965 applies, and that is across the board in all cases, whether it is fair or not, whether it's what you wanted or not, whether it's what you told everyone you were doing or not. If you didn't make a will, the Succession Act applies. There are almost no exceptions. So let's look at what that actually means. What it means is that if you die leaving a spouse or a civil partner or a qualified cohabitant, and I'll explain what that means in a moment, but you have no children, get absolutely everything. And you might say, but that's fine, so I don't need to bother making a will. And that might be the case in your particular circumstances. But supposing I got married to this fella in a fit of romance 25 years ago when I was on a gap year in Australia, and we split up and we didn't bother. I was put off the whole idea of marriage. I didn't bother getting a divorce or anything. 35 years later, if I drop dead not having made a will, even though I'm living with this lovely fella for the last 20 years, he won't get a penny. He might. This spouse can turn up and claim the whole estate. So it may not be what you want to have happen. And if you are separated, obviously, this is a very good reason to make a will, because if you don't make a will, your very less than beloved ex-spouse can claim everything if you were to die. What happens what's a qualified cohabitant? Because I mentioned that. So it used to be that unless you were married or a civil partner, you had no rights at all. But now they brought in, since 2011, similar inheritance rights for a spouse or civil partner for a cohabitant. And you can also get the tax break of 100% tax-free, but that is only for a qualified cohabitant. So it's quite restricted. You have to have been living together for 5 years, for 2 years if you have kids together. And there's other conditions, which I'm not going to go into because we don't have time here. So if you haven't been living together for the 5 years or the 2 years when you have children together and the partner dies, you're not entitled to a thing. You're a stranger at law. You're just like a dog on the street. You have no rights at all. So just to look at that, if you have no kids, then your partner would inherit, your spouse or civil partner or qualified cohabitant. If you do have children, then it's divided up as follows. Partner gets 2/3, 1/3 is equally divided between the kids. And you might look at that and say, sure, that's fine. Why would I bother making a will? But I know a situation where the elderly person died and this happened because she hadn't made a will and the house was in her name. So her husband got 2/3 of the house and the 4 children got 1/3 between them, so a 12th each. So you ended up with the house being owned by 5 different people. All you had to have was one of those children say, Dad, I want my money. And the dad was 85 and in a wheelchair and had no other means. He would have had to sell the roof over his head in order to pay that child off. So what the 4 children did was, they're very reasonable people. They said, we're going to give up our succession rights so that everything goes to dad. And, then it's all just under one roof. So unexpected things like that can happen. It all looks fine on paper, but actually it blows up and it causes a problem. And it's because you haven't made a will. So If the situation is that the person only has children, they were never married, they aren't cohabiting, and they're divorced, or they're widowed, then the children get everything divided equally. And again, that looks really fair. But let's take the situation where Aoife was given a site when she got married. Her parents put her through college. She's a really well-to-do barrister. Brendan has struggled a bit in his life, and he left school early, and he kind of, he was kind of the black sheep of the family, drifted away, and he didn't really get the support that Aoife got. Ciara is only 18, but she won the lottery last week, so she's a multimillionaire. And Damien is 12, and he has Down syndrome. Now, as you can see, there are 4 very different scenarios, but you didn't make a will, so each of the children gets an exactly equal amount, even though it would have made more sense to leave more of the money for the younger child who didn't have the means or who had special needs. So you can see there that one size does not fit all. And then if you have a particular circumstance in your family that you want to look different to this, you have to make a will to do that. So when I say a child is a child of any age. So those children could be like 45, or they could be 12. It's not an underage child. And when I say a child also, it means it includes an adopted child. Okay, but not a birth child that you give up for adoption, a child that you adopted into your home, and not a stepchild. So the blended family there might need to take steps to make sure, by making a will, that all the children, the stepchildren and the blood children, would get equal amounts if that's what they want. So then what happens if you haven't made a will, or if you died intestate and there's no spouse or children? It goes down to the grandkids. If there's no grandkids, it goes up to your parents. If there's only one parent left alive, that parent gets everything. Nobody else in the family gets anything. Or if there's no parents, go to the brothers and sisters. If there's no brothers and sisters, nieces and nephews, all the way down the line. So one step of the stairs will inherit everything. There's no sharing, except in certain circumstances between the brothers and sisters and nieces and nephews. So if I have 2 brothers and 2 sisters, one of my brothers has died before me, leaving 2 children of his own, his quarter share will go to his kids. But that's the only time that 2 steps of the stairs would inherit. Generally speaking, it can go out to all kinds of first cousins that you never met and have no time for and didn't know. So, and then it goes further, and if nobody can be found, the state gets it. So if you want to avoid this, if you say, well, it's going to go to my cousins, but I actually have 2 or 3 special cousins who I really like, then make a will and leave the money to them and not to the ones you can't stand or you never met. Okay. So let state get it. Okay. The moral of the story obviously is make a will. Okay. And I hope I'm preaching to the converted here. So the good news is that it's a very quick process. If you're in extremis, if you're in a severe health situation, solicitors will actually come to your bed in a hospital and so on. It's relatively cheap. I mean, when you consider that 280 euros an hour is the average payment for a solicitor, that is very cheap. You get a big bang for your buck. It's tailor-made, and that's the key point, and adaptable. People get very uptight about making a will. They feel it's like doing your leave and cert. You have to get it right. It's your only chance. I can make a will on a Monday, change my mind on the Tuesday, tear it up on the Wednesday, and make a new one on the Thursday. So it is adaptable to your circumstances. You can change it at any time, small tweaks or big changes. And it's totally confidential. A lot of people are very uptight about that. I don't want people knowing my business. They cannot know your business. I might come back to that later when we have the discussion, because maybe you could think over in your minds who would be entitled to see your will, either before your death or after your death. You might mull that over, and we might come back to that later. Okay, so the other thing I would say from personal experience is do not put it off, because we do not know the day or the hour. Could all be run over by a bus tomorrow. And the other thing is you can get a sudden diagnosis, serious diagnosis out of the blue, which I did about 10 years ago, and things did not look very good at all. I had an 8-year-old son at the time, and that was a frightening situation. And thanks be to God, the first thing I thought was, pull out my will and see, is it suitable, is it up to date? And the will was fine. So I could put that out of my mind. I knew everything was sorted, worst case scenario, and then I could get on with the business of my health and getting better. Now, why I say don't put it off is that I had to start treatment really fast within 2 weeks. I was on really heavy medication, to which I had a very bad reaction, and I was like a zombie. I couldn't string a sentence together. I couldn't walk. I couldn't drive. So I wasn't in a fit mental state to be able to make a will. So had my will not been made already and been up to date and everything, I would have been in a precarious situation and a very stressful situation where you're trying to make a will and the solicitor is going, I'm sorry, but you're not in a fit mental state to make the will at the moment, so it would have been an extra stress. So my point is, do it now while you're in the full of your health and thinking clearly, not in shock or in a situation where you're muddled because of healthcare or treatments. We'll up on to how to actually go about it. I'm going to go pretty fast through this. Last we're talking about is the testator, the person making the will, the executor, who's the person who steps into your shoes on your death and takes care of all your estate and distributes it. If you haven't made a will, you're known as the disponer, and the person who takes over your estate and looks after it. If you haven't made a will, if you died intestate, is called the administrator. So they're kind of parallel tracks. You need 2 witnesses, and as Ian said at the beginning there, the woman who signed her husband's will only saw one witness at the end of the thing, and she said, "Oh God, there's only one. He needs 2," and she put her name down at the bottom, not turning the page over to see the second witness's name on the back, and then she became a witness, or and the witnesses are not. That's why there's a little asterisk there. Are not allowed to inherit for obvious reasons. You can't put a gun to someone's head and say, "Leave me everything." If you're the witness, or you're the spouse of a witness or a civil partner of a witness, then you can't inherit under that will. So you need 2 witnesses, and they need to be there at the same time. It's very, very strict, the whole witness thing. So that's why you go to a solicitor. Then you go to a solicitor, of course. And of course, these lovely ladies are all female, because there are now a majority of solicitors in Ireland are female. It's my little strike for feminism there. Okay, so you go to a solicitor because you would be, quite frankly, deranged to even think about doing this yourself. I compare it to, I'm sure I could download something off the internet about how to amputate my own foot. And I probably could amputate my own foot. And maybe I won't die of blood poisoning. But it's a very foolish idea. It's exactly the same with making a will. You have a professional, a lot can go wrong, pay the professional to do it. Don't even think of making a homemade will. Beneficiaries are people who benefit from the will, obviously, and then the testamentary guardian. Remember I said about children, thinking about young children and their care, not just the money for them, is very important, because if the child is left orphaned, or essentially orphaned, maybe where one parent has always been absent or isn't capable or able to parent for whatever reason, you need to appoint someone as testamentary guardian, and they step into your shoes as a parent. So they would have your legal rights as a parent on your death over the children. And when I made my will, I made my sister testamentary guardian with my son's dad. So they would be both together. So if anything happened to him, if we were both in a terrible car crash, for example, he was in a coma and I was dead, my sister could legally come in and continue to parent my son. So testamentary guardians only last till the child is 18. Well, guardians last, but the guardianship only lasts till they're 18. And then trustees would be people you'd appoint to manage someone's money who's not allowed to manage it themselves. For example, someone who's under 18, or somebody who has severe special needs or might be in an advanced stage of dementia. And then there's always the disgruntled relatives, because as we say, where there's a will, there's a relative. So this is the cast of people you need to consider when you're making a will. And moving swiftly on here, the 7 steps you would take is you choose your executor, your guardian, or your trustee. That's something you really need to think about, and you need to talk to them about it. So it's an ongoing process. You list your possessions and their worth. I'll come to that in a moment. So your possessions might be, house, car, bit of savings. Or you might have possessions you don't think about, like a pension or a life insurance policy or stocks and bonds, something that could cash in later on.
Okay.
And then you might be a farmer. You might have land and machinery and animals and so on. You might be a self-employed person, have your own business. You might be ferociously wealthy and have yachts and racehorses and all the rest of it. You might only have your grandmother's wedding ring and whatever's in your piggy bank. But either way, listing your possessions and their worth is very, very important. And how you can do that, we'll all cry out for the Citizens Information Service, wonderful network. They brought out this thing called a checklist of possessions, and you can download that free from the Citizens Information website. And as you can see there, I'm not going to go through it bit by bit. It is a wonderful document where you get to put down everything that your executor, or worst case scenario administrator would need to process your will and to do probate on the will. And that will make everything a lot easier when you have all these details down in one place, copy of it next to your will where somebody will find it. It speeds up the whole process of probate hugely. And it is very easy to do, but it's quite time consuming actually. I was surprised at how time consuming. So everything will be in there: credit union, stocks, bonds, shares, post office bonds. You might find out you have all kinds of money you didn't know you had. And then you put down who you want to be guardian, who the trustees are, who your next of kin is, where you want to be buried, all that. And I'll just note at the end, digital legatees and passwords for computers and online accounts is vital. And it's something that people don't think about. And I know a man personally whose wife died recently, and she was the one who took care of everything. She had everything, spreadsheets, the works, all the information in the world on her laptop. Did she give him the password for her laptop? No. She's dead. He can't get access to any of the information, and processing the whole probate situation has become an utter and absolute nightmare. So you must put down somewhere, particularly on this list, what your passwords are, what your usernames are, what your codes are for getting into things. And the younger ones among us who have Facebook and social media accounts might want to appoint someone who will keep that account going or close it up after they've died. Otherwise, it can cause a lot of distress when they're kind of live and the person is dead. So you keep a copy of this and you keep it up to date. And so you've listed your possessions and their worth, and you have that copy. So if you close down a bank account, cross it off and write close down on such a date. Otherwise, the poor executor is going through all kinds of boxes trying to find out and ringing up the bank to say, is that bank account still valid, and so on. You decide who gets what. That's the fun bit. If you like Christmas, you'll love that bit. Okay. And then you draw up the will with a solicitor. So much can go wrong. I can't even begin to tell you how much can go wrong. And when are you going to find out if you've made a mistake? After your death, because nobody's going to even look at the will until you've died. And if you've died and they find out there's a mistake, it is too late because you are dead and nobody can ask you what was your intention here, actually. Okay, so any number of terrible scenarios, I can talk to you about some of them at the end, maybe with Ian. Okay, you date it, you sign it, and it has to be witnessed. Now, when I talk about someone witnessing your will, they don't see what's in the will, they're witnessing your signature. So you can say, this is my will, you put a piece of blank paper over it, I'm now signing it, witness my signature. So they don't know anything about what's in it. And if you do it with a solicitor, it's normally the solicitor and maybe a legal secretary or another solicitor that will both witness the will. It's better if it's somebody who's a stranger to you. Okay, you review it, as I said, every 3 years because the will may not fit your requirements. And a classic one there is when you get new grandchildren and you make a will and you leave them something in the will because you're all delighted, and then another 3 or 4 grandchildren come along and you're running around after all the grandchildren and you forget to update your will, and then when the will is read, lo and behold, some grandchildren are left money and some aren't, and that can cause terrible upset because people don't understand it was just an oversight. Keep the will in a safe place. If you make it with a solicitor, they will keep it in a fireproof safe. If the solicitor goes bust or runs away to Rio de Janeiro or dies, the Law Society makes sure that all those documents are passed on and kept safe. My grandmother died aged 105, and we had to go through, I rang up the Law Society because the solicitor that she made her will with 48 years previously was long gone. So they were able to track all the different solicitors' offices it had been in, and we found the original will quite easily. Tell someone, say that you've made a will, see where it is. They're not allowed to go look at it. Nobody can show it to them. Nobody can talk about it to anyone, but they have to know where it is. Particularly relevant if you move around a lot. Now, you do not want to end up in a situation like this. I get this. This is the Law Society Gazette. I get it every month. And this is not a Lonely Heart ad. Can you see this at all? You look here. There's ads in the back of it. Pages and pages. Ellen O'Reilly, deceased, you can see there, of Tullow, County Carlow. Died 1995. Would anyone know where her will is? Okay. Look over here. We have Frances Dunn, 1981. Does anybody know where her will is? Then down here we have Edward Mahon. Oh my God, he died in 1967, and they're still looking for his will. You do not want to end up on this page because while they're looking for your will, everything is frozen. Nobody can pass on property. Nobody can get at the bank accounts. It could be really a bad idea. You don't want to end up here. Tell someone where your will is and keep them updated. So the requirements for valid will then, moving swiftly on, to be in writing, you have to be over 18, of sound mind. And again, it was the situation I ended up in because of the number of drugs I was on. I was suddenly temporarily not of sound mind. Now, if someone has reached a stage of dementia where they really don't know what's going on, it's too late for them to redo their will. The last will they've made will stay. So you have to make it of your own free will, obviously. Nobody putting pressure onto you, and date it and sign it with the 2 witnesses, as I said. Anyone who wants to contest a will has to show that one of those things is missing. You know, you can't just say I'm contesting the will because I'm upset I didn't get left what I thought I would get. You really have to have a reason to show that there's something actually wrong with the will. Or, for example, if I had looked after my aged mother for 40 years and had decided I wasn't going to get married and had given up my chance of a job and everything because she said, I'll leave you the house. And then she didn't leave me the house, I could contest the will there because that would be a testamentary contract. So, you know, there are cases outside of these that you can contest a will, but they're few and far between. If you make sure all of this is taken care of, you have a pretty watertight will. So someone who says, I'm going to contest the will, you say, oh, what is it that you can prove that is wrong with it? And if they stand there like a goldfish, you don't have to worry about them. What can you use your will to do? This is the point of the whole thing. You can appoint guardians for your kids, set up a trust to manage the money. You can give out your estate to various people. You can reduce your taxes and legal fees. You can disinherit your enemies, okay? So how you disinherit them is you make a will and you don't leave anything to them. Now, there's an asterisk there and an exclamation mark because you can't cut out your nearest and dearest. You can't cut out your spouse or partner or children 100%, and I'll come to that in a minute. You can leave somebody like a life interest or right of residency. So I might say, I'm going to leave my grandmother's diamond ring to my son, but only for his life. And then when he dies, it's to go to his daughter or his firstborn child, so that you keep it in the family. Or you can leave a right of residency, like you can say, Granny has to have the right to live in the house until she dies, but she doesn't get to own the house. So you can leave things in different ways. It's not a matter of just giving an object 100% to somebody. You can make a conditional bequest. I leave 2,000 euros to my son on condition he finishes his degree, because I know he's always into dropping out at the last minute and what have you. You can donate things to charity, and if you get onto the charity you want to donate to, they will give you a section that you put into the will, and you can make a tax-free donation to them. Please don't give your body to science, apparently they've too many, or organise your funeral in a will, because you'll be well dead and buried before they ever get to look at the will. That's not a good idea. So, okay, so I just wanted to pause for thought a bit here. And again, if we have the discussion at the end, think about any vulnerable members, dependents, or family members that you might have, and how, in light of what I've said there, they could benefit from you making a will. For example, just to throw out an example there, if I had a brother and I wanted to leave him money, or a son, say, and he had really serious drink and drugs problems, and I thought, if he comes into a load of money, he's going to kill himself. He's just going to have a blowout and buy it. But I don't want to not leave him money because I want to take care of. I could leave money in trust for him. So say his godfather and his sister could be joint trustees, and they would manage the money for him, pay his rent, make sure he had an account at a shop where he could buy food and all the rest of it, but not get a huge lump of money in one big lump sum that possibly might be the undoing of him. So there's different ways that you can engineer things that you can leave money to people in precarious circumstances. Or if you have a vulnerable dependent, you think if they get a load of money, these people might, you know, inveigle it out of them. So you might make sure that they get a regular income rather than a load of money. Guardianship, just to look at it very quickly, is you're giving the person the right to make major decisions about the child's life. All of those decisions. They go to school, you know, what religion they're brought up in, whether they emigrate or not, all that kind of thing. It only lasts till the child is 18. If your kids are over 18, you don't have to worry about guardianship. Now, even if there's special needs, so you might have a special needs child who's 23, will never be able to live independently. Guardianship, unfortunately, isn't the solution there, because it only lasts till they're 18. And it doesn't apply to money. It's only to make those decisions. It's not to have the money to spend on behalf of the children. So if you want to have money left for somebody else, you make a trust. And it can be the same person that you nominate as the trustee and the guardian and your executor. You know, these roles are interchangeable. So how a trust works is that you leave the money, the testator wants to give the money to the beneficiary, but they can't for whatever reason. I've given you some there. And they instead leave the money to the trustee, who manages the money on behalf of the beneficiary. And that has to be very much above board, and they have to keep accounts and so on. Again, don't go meddling around too much, because we do not have a crystal ball. We don't know what the future holds. So it's not good to try and kind of manage from beyond the grave your offspring's life for the rest of their lives. You know what I mean? It's not a good idea, because you don't know what the future holds. You don't know what might happen. Unexpected things might occur. So it's good to keep a will relatively simple, and you can talk about that with your solicitor. Discretionary trusts are good. You set up a trust because it allows the trustees to decide how much they give and when, rather than say you're to give X amount per month. You don't know what's going to happen with inflation and so on. And the benefits of the person can be protected. So say the beneficiary is on a medical card, well, the trustees can give them enough money that they're still below the threshold and they keep their medical card. On the other hand, if they become wheelchair bound and need a wheelchair ramp put into the house, they can release 20,000 to do that, say. So there are also tax breaks for the maintenance and care of a permanently incapacitated person. Now be careful. This is not a disabled person. This is a permanently incapacitated person. There's a difference. So the revenue determines that as somebody who is incapable of managing their own affairs. If you look at some different special needs situations here, you might have a lovely little girl who is unable to manage her own affairs, and that's a permanent situation. You might have this lovely little boy here who is obviously disabled, he's perfectly able to manage his own affairs, and he might end up running a whole chain of restaurants or becoming a famous actor or something. You don't know. So there are different situations with mental health issues, Alzheimer's, dementia, and it depends on the level and whether or not you're able to manage your own affairs. And they do that on a case-by-case basis in the Revenue Commission. And interestingly, a recent case, they decided that someone who's in the throes of addiction and alcoholism is determined by the revenue as being capable of managing their own affairs, even though other people might disagree there. So not all situations have tax breaks in a nutshell. So what can't you do with a will? Okay, there are things that have multiple ownership. You're either a joint tenant or a tenant in common. This is about owning a house, for example. And I give the examples. Joint tenants, like people who own a dog together. Now, if I owned a dog with Ian, I wouldn't say, Ian, you own the front legs and I own the back legs. I say, we own the dog together. If I die, Ian gets the dog. If Ian dies, I get the dog. Whereas tenants in common. So it's the same with the house. If you own the house as joint tenants, the last person left standing inherits the house automatically outside of the will. If we're tenants in common, say I bought a house with Ian investment and I paid 10% and Ian paid 90%, I own that 10% slice of the pie, like as if it's a pie, and Ian owns the 90%. So if I die, I can leave my 10% of my will to someone else. Or I can say, Ian, I want the money for the 10%, buy me out, or we'll sell up and take the money and go our separate ways. So that's tenants in common. So you can leave something to somebody else in your will if you own it as a tenant in common. But if I own a house with my partner and we're joint tenants, I can't leave that to anyone else in the will because on my death, it automatically goes to him. So those are things you need to think about if you're talking to your solicitor. Okay. Other thing you can't leave in the will is a joint bank account. Joint bank account, then you die, the other person automatically gets what's in that joint bank account. It goes by survivorship. And there's also things that you can nominate, credit union and post office funds, that goes automatically outside of the will. So these are things that you need to check about if you're making a will. So you can't leave a right of residency, life interest, and so on. So I can talk about that again later. But intestacy, we told you what would happen if you died intestate. And with testacy, what happens there is that the terms of the will apply. Obviously, you made your will and what it says in the will happened. However, there's always a however. Remember, I told you can't disinherit certain people. The spouse, the civil partner, or the qualified person may have a legal right share. I'll give you the example here. With Paddy and Patricia, married for 40 years. Paddy drops dead. They have 4 kids. They find out the will leaves everything to the mistress, Esmeralda. Panic ensues. Well, you say, Patricia, don't panic because you are the spouse. And if you claim within 6 months, you have a right to a legal right share, no matter what the will says. And so she will get a third, no matter what the will says. And the rest, unfortunately, will probably go to Esmeralda. Now, that's because Paddy and Patricia have children. The situation, if you don't have children, is that Patricia would get half, which is totally counterintuitive. You'd think you'd get, more if she had children, not less. But she would get half if there's no children and she applies within 6 months, and the other half goes by will. That's a way of protecting spouses from being disinherited. And then with children who've been disinherited, it's not quite as clear cut. They don't get a set percentage. They have to go to court and they have to make a claim and they have to prove that they weren't properly taken care of as a proper parent would. Now, that's only if there's a will and they're left out of the will. So, and they'd look then, if I obviously gave my children a site and a load of money and all the rest of it during life, that would be taken into account if I decided to leave them a bit less in the will. So they look at what the child got throughout the life as well as in the will, and if that's fair. And they take into account if the child had special needs or was particularly young and all of that. So that's what the children would have to do if they were disinherited. Just very quickly then, I'm going to wind up because I'm sure Ian would like to have a chat and the rest of you might have questions. What happens after you die? The practical points I made there is your assets will be frozen. The wolf can come to the door and probate can take a long, long time. Out your checklist of possessions. In the name of God, be organized. It will speed up the whole thing. If you want to keep access to money, make sure you have a joint bank account. And then if you die, the person who's the other person in the joint bank account can continue to take the money out. It won't be frozen if it's a joint bank account. And you can nominate credit union shares that will immediately go to another person, which can be very useful for paying, bills to do with the death and the burial and so on. I'm not going to look at the personal representatives. It's just what you do. So what probate is the process whereby somebody has the legal authority to wind up the dead person's affairs and give out their estate. And that can take a long, long time. It can take, did we have it here? No, going up. So what they do is basically they get the money together, they protect the estate, they pay off the debts, they bring in what's owing, pay the funeral, all that stuff. Very importantly, they get the revenue and the social welfare to give the all clear. They check everything is hunky-dory, and then, only then, are they allowed to distribute the estate. So how long it can take is the average time, 16 months. Average. It can take a lot longer than that. And if you have a good checklist of possessions, it'll speed up that process. You don't want all your money frozen for that. That's why it's so important of joint account and so on. Okay. Now, how to reduce inheritance tax very quickly. I'm just going to do a quick visual here to give you an idea. Okay, nothing is certain but death and taxes. He looks pretty happy having said that. Benjamin Franklin, still true even centuries later. So at the moment, 33%, a third, is what you pay in inheritance tax over a certain tax-free threshold, thanks be to God. And that tax-free threshold will depend on your relationship to the dead person. So if you have a quick look here, it changes every year in the budget. This year, if the spouse or civil partner are qualified cohabitant, living together for 5 years, or 2 if you have kids, you get 100% tax-free. So that's the good news. We should all get married. Okay. If you're a child of the person who's died, you're entitled to get 335,000 tax-free. And after that, anything over that, you pay a third. If you're in close blood relative, a lot less, you get 32,500 tax-free, and anything over that, you pay a third. And if you're anybody else, you get first 16,250 tax-free, and you pay a third over that. Now, those are cumulative. So if the child gets 300,000 from the father, they don't pay any tax. But if they get another 300,000 10 years later from the mother, they're added together. That's 600,000. So they'll pay everything over the initial 335,000. So you add them up within the group. If it's a close blood relative, if I get something from my uncle, something from my aunt, something from my granny, something from my cousin, they'll all be added together over time. So over time, you'll go over the threshold. After that, you're paying a third on everything. Just to give you an example of tax planning, because I said that's quite important. I'll give you an example here, a very simple one. Testator is worth 800,000. Her estate is 800,000 euros, just because I'm very bad at maths. And they have a son and a daughter. So he or she is a son and a daughter. So they say, look, I'm going to be fair. Half to 50-50 between the children, that's fair. And they write a simple will, homemade will, and they do that. And of course, because they made a homemade will, they didn't go to a solicitor, they didn't get good tax advice. And this is what happens. The son gets 400,000. If you see here at the bottom, minus 335,000 is the tax-free allowance. So the son has 65,000 that they have to pay tax on. And 65,000 at 33% is 22,000. And the daughter is in exactly the same position, and she pays 22,000. So there's 44,000 paid in tax because both of them inherited more than the tax-free allowance. Okay. Now this is what the testator could have done with exactly the same amount of money and the same scenario if they had had good tax planning. So they would look at, oh, the tax breaks for the child is 335, 3250 for the 500 for the group B, and group C is 16. And then they go back and they look at the situation and they say, I'm going to give 335,000 to my son and daughter. They pay nothing. I'm going to give 32,000 to each of the 3 grandchildren because they're entitled to inherit 32,500 tax-free. They pay no tax. I'm going to give 16,000 to my son's spouse and 16,000 to my daughter's partner because they're group C and they're entitled to inherit 16,000. And then you have the lovely scenario where 2,000 left over and you decide, I'll give that to charity because that's tax-free too. And you end up paying a tax bill of 0. That is the difference between tax planning and no good tax planning. 44 grand in this particular instance. So you'd be crazy not to do it. And again, as I said, it changes year on year, which is why you need to take the will out and have a look at it, because you might find, oh, the tax brackets have changed and I could, rejig what I leave to whom, or there might be more grandchildren that you could, spread the money across. Another thing that you can do here, there's a load of tax breaks, like a dwelling house inheritance tax break. If it's a testator's only home and the beneficiary has been living there for the last 3 years and doesn't sell it for 6. So there's a load of those. Revenue can tell you about those. The farmer business 90% tax break. There's a favorite niece or nephew tax break if you're a blood relative who's been working in the farmer business for an length of time before the death, and you can get a huge amount, the same break as a child would. So how to reduce your tax? Spread your requests, like we showed there. Marry the person, obviously they get everything tax-free, or cohabit for the length of time. You can make charitable requests, they're tax-free. There's a whole load of tax breaks, as I said, and you can give things in different ways. You don't have to give them the house, you can give them the right to live in the house, for example. And you can leave a bequest free of tax, which means that you'll be paying the tax for the person. There's different things you can do there, or you can give your money away in dribs and drabs. I just want to ask, how many of you here, maybe you would type in on the chat Y if you're aware of the small gift tax break. Just type in Y to Ian, and he can tell me after how many of you were aware, how many Ys he got, how many of you are aware of the small gift tax break, and how many of you might be taking advantage of it. And this is what it is. It sounds too good to be true, but it's for real. If you make annual tax-free gifts during your life, rather than waiting till you're dying and leaving it in the will, of up to €3,000 per person per year, an annual thing, you can get it completely, the people who get that money get it completely tax-free. And those gifts are not added up and taken off your tax-free allowance at the end. You might say, well, sure, I'll give it to them during life and then they won't pay tax. The bad news is gift tax is also 33%. So whether you leave it to them while you're alive or you leave it to them when you're dead, they're going to pay tax on it and it's going to accumulate. Their tax-free threshold will be chiseled away. Whereas if you give money to people in dribs and drabs, not more than 3,000 per year, to a larger number of people, that doesn't add up and chisel away at your tax-free allowance. So that's a really good tip, that you can give money. Like if you have a family, say your son and daughter-in-law have 3 kids, I mean, that's 15,000 that you could give them in one tax year, and there's no tax liability for anybody. So be careful though, if you're doing this, don't chisel away all your money while you're still alive. You may well need it, and none of us knows how long we're going to live. It's a good one to do, and what that testator could do during their life, even giving money in small dribs and drabs. You know, you could set up an account for your grandchildren and be putting the money in towards their eventual education or what have you. So some general points: please never make a homemade will. You can change your will at any time. I'm not going to go into these because I think we'll have to chat. It might be better. Where do you go from here? Organising your affairs, set up a joint account, definitely, and nominate people to get money on your death. Would stave off the evil hour if the probate takes a long time. Fill out your checklist of possessions, absolute priority. Go over what you want to do, discuss it with the key people. We're great at talking about stuff. We never talk to people about the things we should be talking to them about. Write your letter of wishes. Now that would be, I said, I'm leaving all my personal belongings to my sister. And then my letter of wishes might be, can you leave these earrings to my friend Mary because she really likes them? And can you leave this necklace to my other friend so-and-so because she admired it once? You know, you can give specific things to people, but it's not in the will with all this minutiae. It's just what I tell the person who's going to distribute it for me on my behalf. It's not legally binding, but it's a handy way for, you know, organising small stuff. Give it away during your life in dribs and drabs. And again, don't forget the Citizens Information Centre, because they will keep you up to date every year, and their phone service is there on how to go about it. If you have any questions about any of those, you can contact them. So what you do next is everything I've mentioned there, and take action. You choose your solicitor, ask around, find out who's good, make an appointment, and again, ask the solicitor how many wills they would do in a year. If they only do 2 wills in a year, that's not really their area of expertise. Find someone who does quite a lot of them. It may not be the person who you know, do the conveyancing in your house or whatever. And then you make your will and have it signed and witnessed. Read it before you sign it. Tell someone where it is. Keep it all updated and in a safe place, and then you can relax. You only have to review it every 3 years. You mightn't have to do any updating, or you might just do a quick peek. And where you go from there is enjoy your peace of mind. Spread the word about everything that I've told you to all your friends and relatives. And if you're interested in getting information about this online downloadable step-by-step guide that I'm going to be bringing out soon, you can get on to me at makingawillwon'tkillyou@gmail.com. So I also do presentations for other special interest groups. You can get on to me at the same email address. So there is huge peace of mind when you've made your will. You can sit back and say, well, right, I've sorted out the inevitable, and now I can get on with enjoying my life and being in the here and now. So I know I've only left a very short length of time, so I'm going to sign off here and ask Ian if you'd like to come back on. And I see there's a bit of chat coming in there.
Great, Anne. Thank you very much. That was really informative, interesting, and a little scary as well. I think that, you know, you've put so many things in front of us that I'm sure people do have questions. If people do have a question, can you unmute yourself and speak?
Ian, can I start off with a question?
Yes, please, Robert.
Good, Anne, thank you very much. Could I just ask a question about the tax-free gifts?
Yeah.
If you give a gift to somebody, who has to declare it to the taxman? And if the recipient needs to declare it and they don't, is the person making the gift guilty of fraud?
No, not at all. It's up to the recipient to declare it. And I just say that if you say give a second-hand car to your son and it was worth 5,000, he will get the first 3,000 tax-free. So that's kind of automatic. But you do, when you're making the declarations, when you get an inheritance, you will have to send in stuff to the taxman and you'll have to sign it, an affidavit and all the rest. So it's a serious thing to not let on that you got gifts during life that were worth over 3,000, because those will be added up and taken off your tax-free allowance. So it is up to the person to self-declare, and people go, sure, that's grand, I won't mention a word. So they have very long reach and they have a long way, they have a way of finding out, and everything is kind of linked up with computers now. But it's not a problem for the person who's giving the money. It's the issue is responsibility for the person receiving it to make the declaration.
Thank you very much. Thank you.
Okay. Thank you, Robert. Does anybody else have any questions? I'm sure things will occur to people afterwards. Yes?
I have a quick question. If you have a will and you have, I do, please.
Oh.
If you have a will, which I did,
yeah,
and I also have endurable power of attorney for a niece and nephew,
yeah,
do I need to make them also on my checking account?
Sorry, enduring power of attorney now is something completely different. So you've given them enduring power of attorney should you become incapacitated. Isn't that right?
Yeah.
You've made them, you've given them enduring power of attorney over you if you were to become incapacitated. Well, then if that kicks in, God forbid, then they would have a right to access all your bank accounts automatically anyway. So you wouldn't have to mention that in the will at all. The will is only about after death, and enduring power of attorney is only between incapacity and death. So they're kind of two separate things. You wouldn't have to worry about that.
Okay. Okay. Thank you.
And I must say, I commend you, because not many people have done enduring power of attorney. It's something we should be thinking about too. And I do another talk on that. Thanks, Eileen.
Okay. I'm going to draw this to a conclusion, and anybody who is interested, I will be putting a recording of today's talk with Anne up on YouTube later today, once I've managed to edit it and ensure that it's fit for presentation. Anne, thank you very much for all that you've done. You might send us any documents that you think would be useful. For example, a printout of the checklist of things that people have might be.
Yeah, I can send you a link and then people can download it themselves.
Excellent.
It's better to download it in an electronic format, because it gets longer as you fill in information then, rather than have a static one and then you're running out of space. Yeah. So I can send you the link for that, no problem.
Great. Thank you very much.
It's a pleasure. And I must say thanks very much for asking me to give the talk.
Now, and Anne is available to voluntary organizations to give talks. Obviously, there are fees to be covered, but if you think that Anne's training is of value, then she is available. Even once county-wide travel is allowed out, she can leave the Beara Peninsula. Not that you'd really
I can do it online as well. So yeah, exactly. But I'm happy to do it in person. Yeah.
Yeah. Okay, everybody. Thank you very much for joining us today. And I look forward to seeing you next week, when we'll be joined by John Hayes, who is a sculptor who uses a chainsaw on tree trunks. And he's also involved in the Waterford development that's breaching into the Kilkenny county boundaries. We look forward to seeing you next week with John Hayes, and I look forward to seeing talking with Anne again at some stage in the near future. Thank you very much, everybody, and look after yourselves. And now go and make an appointment with your solicitor to make a will. Bye-bye now.
Exactly. Thanks, Ian. Thank you very much. Bye now. Nice to meet you all.